Today we're going to discuss the top 3 things you need to know about reentry permits using Form I-131. I'm immigration lawyer John Khosravi. I help people get reentry permits all the time. Unfortunately, it's become a more complicated process due to USCIS delays. But these are the top 3 things I want to mention for people doing it on their own or if they hire an attorney to watch out for because they become big problems. Again, I'm immigration lawyer John Khosravi. If you want to contact our office, please email us or go to our website at jqklaw.com/contact. So let's start out by what a reentry permit is. Now, if you're a green card holder, a lawful permanent resident, and you need to spend time outside the United States more than 6 months, it's best to tell the US government ahead of time that you're going to have this absence and get permission, again, using Form I-131 and sending it to the government. And by getting that accepted and a reentry permit approved, it gives you a time period, usually up to 2 years, where you could be outside the United States and have had a previous explanation to the government, letting them know why you're out, so that when you come back in at the airport, they don't try to take your green card away or not let you in. You can show the reentry permit and get back into the United States. So it's not guaranteed it'll work. They could always hassle you and say you've been absent for too long, but almost always, if you have the reentry permit approved in hand, it's a really strong indication that you did not intend to abandon your residency, because as a green card holder, you're supposed to be living in the United States and maintaining your residence here. But obviously, sometimes you may have school back home, court cases, family members that are sick, all sorts of issues back in your home country that require you to have extended absences abroad. So it's better to get this ahead of time than have the issue come up later on if you did not get it. So the first 3 things I do want to mention about the reentry permit that you have to know are: 1, you have to physically be inside the United States when you file Form I-131 for a reentry permit. This is the biggest mistake I see people make when they apply on their own. They'll be outside the U.S. and they'll mail it in, or they'll file the case and immediately leave the United States. But it can't be that. When the government gets the file in hand, you have to physically be in the United States. And if you're not, it's an easy denial. It may take them 2 years to give you notice that they're going to deny your case over this issue, but it is an immediate denial once they decide to look over your case. So don't get a case unnecessarily denied for that reason. Now, the second thing I want to mention about reentry permits is typically approved for 2 years. So once you submit it as approved, the reentry permit is like a little booklet, it's a little passport booklet. They're valid for 2 years. Now, if you've been absent from the United States for more than 4 out of the last 5 years, they may give you only 1 year's worth of reentry permit. So be mindful of that. But that is some time limit that's there. Now, you could always get a new one once this one expires. So be aware, it's not called an extension or renewal. It's just applying for a new one. But that's something that's possible. And the third thing I want to mention is that it does not affect naturalization in any way. So people think that by filing a reentry permit, they may keep the time that they're outside the United States and have that go towards their Form N-400 naturalization, the citizenship application, where you have to have a certain physical amount of time in the United States as well as continuously residing here. It does not help in any way towards citizenship. And then the second thing I hear the most, pretty much the first thing I hear the most about this worry, is that by applying for a reentry permit, it hurts your citizenship case because it shows that you don't intend to live here. But they have no effect on each other. The intent of the reentry permit is simply to not lose your green card if you have extended absences abroad. Now, if you are outside for too long or more than 6 months, that absence on its own will create problems for citizenship, but it doesn't necessarily mean it's going to be a problem. Filing a reentry permit is going to be a problem for citizenship itself. It's the absence, not the application for a reentry permit. Now, I do want to leave you with a bonus point, is that on the Form I-131, if you're applying for a reentry permit, it does ask if you've ever filed U.S. taxes and claimed to be a non-resident. By claiming to be a non-resident, it becomes a big problem because you're saying I'm not a resident, whereas in fact, as a lawful permanent resident, also known as green card holder, you have to be residing here. So make sure you're not checking these boxes wrong and you're not filing your taxes incorrectly. I'm not an accountant or a CPA. I can't advise more about that, but it's very important to be mindful of that issue. If you do want to have a consultation time with us to get more deeper into your case, please go to our website, jqklaw.com/contact, and fill out the short box there with your name and contact information so you can apply with information about taking the next steps with our office. Thank you so much for listening, and I wish you all the best in your travels.